Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today, IP frameworks in contracts for emerging technologies. I'm your host, Julian Dibbell. I'm a partner in Mayor Brown's technology and IP transactions practice. I'm joined today by Brad Peterson and Spencer Glende, also both partners in our technology and IP transactions practice. Brad helps clients reduce cost, improve operations, innovate and increase revenue through technology services and license agreements. Clients trust his counsel on matters regarding information technology outsourcing, business process outsourcing, cloud services, and platform and marketplace services. Spencer counsels clients on transactions to develop, acquire, and commercialize products, services, and intellectual property in tech-centric industries. He has extensive experience structuring and negotiating complex commercial agreements, technology development agreements, and strategic transactions, including collaborations, IP licenses, and channel partner agreements. It's great to have you both with me here today. Let's get into it. Let's start with the basics and with the most basic question of all, I guess. What do we mean by emerging technology?
What we mean by emerging technologies is technologies that have gotten beyond the point of discovery and you know the Nobel Prizes are all won, things of that sort. And now it's emerging as a technology that businesses can use to accomplish business functions.
Yeah, some good examples of that might be agentic AI or even quantum computing or in other areas, synthetic biology or alternative energy, blockchain security. The list today just goes on and on.
Okay, yeah. The technologies we're hearing about on the news and reading about in the headlines, all these exciting new developments. Another basic question, though, why are contracts around these technologies fundamentally different from contracts involving more established types of technologies?
Julian, the biggest factor making these contracts fundamentally different is the level of uncertainty. Emerging technologies are relatively new, they are quickly evolving, they have unclear potential applications and impacts within a business, and they carry unforeseen risks. As a result, implementation of an emerging technology, unlike something which has been productized and is plug and play, involves iterative, collaborative development. And inherently, that means it's hard to value.
Yeah, with the emerging technologies, neither party knows exactly what the development path will look like or what the end result even will be. This uncertainty affects everything about it: timelines, deliverables, valuation, as Brad mentioned, and IP. It might be impossible to know from the outset what kind of IP will result from the relationship, whether it's valuable or in what ways to which party. And therefore, it becomes, in many cases, a real challenge to allocate ownership or usage rights, again, especially from the outset. And one reaction to that often is to try and lock everything down with, the most, self-protective positions. If you try and do that, you might wind up with misaligned incentives or stifling of the other party's willingness to innovate or structures that don't fit how the innovation really unfolds. This could cost precious time. And in some cases, it could erode trust, even at the beginning of the relationship, as the parties' negotiation becomes, overly position based rather than, as they're trying to deal with this uncertainty ahead.
Yeah. Okay. So can't lock everything down at the start. And for a transactional lawyer, that's hard to hear. Like, we really like to have everything buttoned down as much as possible ahead of time. So instead of doing that, what can we do from a contracting perspective?
Our goal is to put the parties in a situation that fosters innovation and drives achievement of valuable outcomes. Yes, we need to have deliverables and success criteria. Yes, we need to allocate risks. Yes, we need protections around confidentiality and other standard legal terms. But primarily, what we want to do is create a relationship of collaboration and trust. And thus, it's important that the contract feel fair to the parties and to the people who need to be creating the innovation.
Yeah, Brad, that's I think a really important point. You mentioned people, and I think a theme that we might come back to a few times here as we discuss is that these are human beings working together, right? Sometimes we think a contract is this, kind of abstract, self-executing sort of a thing, but ultimately it's about teams of people who are going to have the best chance of success if they really do trust each other, feel like they are aligned rather than pushing against each other. And so that's again one reason to be sensitive to the risks of kind of pushing too hard up front, where it might feel like a win because you're getting the most rights in the contract, but the result might be the other side has a lower degree of trust or lesser incentives to give it their best, to contribute their best people or their best ideas. So on the other hand, if you give away too much, you might end up without the benefits that you need if the innovation succeeds. So it is a delicate balance.
Right, and there's also the question of feasibility, right? In emerging technology contexts, sometimes no one knows whether the problem can even be solved, right?
Yeah, right. Which means that concepts like, legal concepts like breach and failure to deliver don't really work well. There's a spectrum of possible outcomes, including some that the parties will not be able to imagine in advance. The parties will want their innovation teams to pivot and recalibrate naturally as they see more and less valuable possible outcomes for the parties as a whole.
Yeah, and because the outcome of the innovation effort is uncertain, what we would like to talk about and encourage listeners to think about is creating IP frameworks that make room for the possibility that the effort is valuable, even if the solution or a particular solution isn't guaranteed. A framework that allows for the kind of pivoting that Brad's talking about and a dynamic relationship rather than one where the parties are trying to apply hard and fast rules to unforeseen situations.
So an IP framework is kind of the alternative to locking things down. It's kind of establishing the parameters within which people can, the partners in the innovation can pivot, be flexible, and adapt to the emerging circumstances of the innovation, right? So what are the primary benefits to achieve and then problems to avoid if you take this approach?
So, taking this approach where we're using IP and the value that's being created as IP as a way to motivate the parties to work together effectively, the benefits you want to achieve are first, each party wants to protect its own existing assets. We're talking here about sharing the innovations, not sharing existing assets. We want to reward innovation fairly. We want to position the parties to create joint innovations. We want to maximize the overall deal value, and we want to allow the parties to quickly resolve disputes, because the worst thing that can happen, of course, is that the innovation stops and the emerging technologies are not implemented. They don't emerge because the parties stop working together. So, on the risks to avoid, In addition to, slow resolution of disputes, the parties will both be concerned about jeopardizing their existing IP. They'll be concerned about chilling innovation by setting up the wrong framework. And by chilling innovation, imagine, for example, that a party says, if I contribute my innovation to this effort, I'm going to lose more than I gain. So I'm going to hold back information or assistance that would be valuable to the overall effort because the IP framework gives me an incentive to do that. Similarly, impairing or tying up value, creating a framework which is so restrictive in some ways that it means that value that could be created can't be created. And then, of course, the biggest risk to avoid is that you wind up with a dispute, a feeling of unfairness, a feeling of bad faith, a feeling that somebody's withholding, et cetera, that ends the innovation effort before the value is created.
Okay, so those are the overall goals, the things to aim for and the things to avoid. Let's get into how you actually then build these IP frameworks. How do you make frameworks that actually work in the context of these uncertain innovation environments? You both emphasize that flexibility and collaboration are key. What are the keys to success in using IP frameworks for innovation?
Great question, Julian. And as we've looked at this, and we've identified 4 real key elements, key ingredients to this recipe. The first I would describe as clarity of common purpose. The second is the mechanism of joint steering committees or some kind of joint governing arrangement. The third is a mindset of maximizing innovation value, which we'll talk more about what that means. And then the fourth element is flexibility and optionality. Brad, you want to maybe add to that a bit?
Starting off on the top, the first key to success, if we're bringing people together to do a new, joint, novel project, is a very clear alignment on the shared purpose of the relationship. Why are we here? Why are we in particular partnering on this? What are we trying to accomplish? Where's the value? And that shared purpose needs to be well articulated and understood by the entire team, so it becomes the North Star for IP decisions, for governance decisions, for resource allocation throughout the project.
Yeah, and even the process of articulating that joint purpose, that shared common purpose, forces alignment early. When the parties work on that together and get to agreement on what the purpose is, they often discover underlying assumptions or expectations that they haven't discussed. And addressing those early prevents problems down the road. Might even help the parties realize that they weren't on the same page in the way that they thought, and it might be better to look for a different opportunity. So it's an important process.
Okay, so working out a clear statement of purpose, that's the first key to success. The second one you mentioned, I think, Spencer, was joint governance, right? And you mentioned joint steering committees, but tell us more about that. What's a joint steering committee?
A joint steering committee is a contractually mandated governance mechanism. And what the contract does is it states that the joint steering committee will have decision makers from each party, and the joint steering committee will be run by the innovation managers from each party. And that joint steering committee will have a specific set of agenda items. It'll decide on strategy, investments, related changes, and IP allocations. It'll agree on the IP contributions and innovations. It'll interpret and apply the IP allocation provisions, and it'll define the strategies, processes for IP procurement, protection, enforcement, and exploitation. It will define the strategy and processes for IP protection, enforcement, or exploitation. And when we think about this as a joint committee, it may not actually amend contracts, it may not actually make decisions, but it will create the alignment necessary for the parties to amend the contract and take action together.
Got it. So that's what a joint steering committee does and how it functions, how does it help with the overall purpose of the framework?
Yeah, I think a big part is it adds at least some predictability in this uncertain environment, right? The emerging technologies, as we talked about before, are inherently uncertain, but at least you have a predictable way that you're going to work together. And the human beings on the committee can develop a rapport and a trust that helps them to make what would otherwise be very challenging decisions, knowing that kind of knowing the history of the relationship, the common purpose, and so forth. So it's a structured way to make those decisions together as the technology develops or emerges. And that's crucial. New IP might come out of the project unexpectedly, or project priorities might shift. And the JSC can evaluate each party's contributions. They can categorize IP and make allocation decisions and adjust strategies in real time. And one thing I'd maybe emphasize there is, in the contract itself, something like IP allocation will likely have some guidelines. For instance, a party will solely own any intellectual property that is developed solely by its personnel in such and such, primarily related to such and such a field, or that is primarily an improvement on its background IP, something like that. It all sounds nice, but applying those guidelines to any given situation may not be kind of a self-explanatory process. And it's often easier in real time and dynamically for the JSC to look at the list of this month's innovations and say, hey, this one fits in that category, this one fits in this one. Ooh, this was something we didn't think about. And when that allocation happens dynamically, there's often less friction than if everybody waits till 3 years after the deal and there's a dispute and then tries to go back and figure out who owns what based on what later becomes known about the value of the technology. If that makes sense.
So it's helping the parties adapt as the innovation evolves. Adaptive, responsive, dynamic. That all sounds great, but what about when the governance breaks down? Like, what about when the Joint Steering Committee gets stuck?
Great point, Julian. Deadlock mechanisms are critical. The advantage of this setting up an IP framework is to allow the parties to decide in advance at the start when getting aligned on how difficult decisions will be made and how we're going to get unstuck in positions where the parties do truly disagree. There are many mechanisms that lawyers have come up with for getting unstuck. One of them is to turn the decision over to one party or the other party. Another is to say have some sort of a expedited arbitration process, maybe final offer arbitration or baseball arbitration, to create incentives for both sides to propose reasonable positions. But it's essential that the parties think through that question at the very start so that a JSC dispute doesn't slow down the innovation.
I might just add that something like a tiebreaker, having one party versus the other have the final say when there's a deadlock. It doesn't always have to be the same party. You could consider, based on the common purposes. Again, going back to the first key that we talked about, it may be that certain types of disputes are best, finally decided by one party and others by the other party. So you can be creative in kind of how you approach that.
Okay, so a very kind of functional joint governance, key to success. Clarity of purpose was the first one you mentioned. Third key to success, maximizing total innovation value. What does that mean in a contracting context?
Yes, that's about taking a broader view of what success looks like, rather than focusing narrowly on who owns each piece of IP. The parties think about how to ensure that the innovation as a whole reaches its maximum potential. And that can mean sharing of upsides, sharing commercialization opportunities, or structuring the actual contributions so that each party feels well incentivized.
And it's a mindset that discourages withholding. And if you build it correctly, and this is part of the agile methodology, you create a sense that we are one team and we are moving toward a joint objective, as opposed to having the parties look and say, yeah, it might be better to hold back resources, information, or expertise from this particular venture.
Okay. So, and contractually, what kind of tools help parties get into that mindset? What makes that possible?
Well, one tool that often comes to mind first is joint ownership. In fact, sometimes we see contracts where people just naturally, as they're discussing it, they just naturally say, well, what's ours is ours, what's yours is yours, what we do together is both of ours. Let's just have joint ownership. And that can be one tool, but it does bring some really serious challenges and complexities as well that vary by jurisdiction. So that's one to not to necessarily write off, but to be very cautious in how it's used, because just saying joint ownership might have unintended consequences. But other options could be broad cross licensing, giving both parties the freedom to benefit from the innovation where appropriate, in line with the shared purposes, and that supports collaboration without really getting too bogged down, or without having to get too bogged down on rigid ownership rules. Focus on the rights to commercialize, the rights to innovate, rather than getting hung up over ownership. And the main point, though, is to think of this innovation value as maybe in light of the adage that the rising tide lifts all boats, right? The goal is not to keep your boat down and mine go up, but let's get the tide higher. And so it's a mindset, and it can be a guide for how you allocate the IP rights in the contract.
So it's kind of about very simple now, making the pie bigger rather than focusing on your share of the pie is sort of the maximizing total value key. Fourth, I think you mentioned flexibility and optionality. What do you mean by that, Spencer?
So that is the ability to pivot, and that could include things like evaluating or adjusting the IP silos themselves and the rights as the project stages go from one to another. Another element of this is considering IP rights in connection with contract off-ramps. What happens when it's time to go elsewhere? Another element is license expansion options. This might allow a party to essentially pay an option fee or otherwise exercise a right to obtain additional bundles of rights, depending on whether those become important to the party as time goes on, such as commercialization rights or sublicensing rights. One challenge with that, of course, is that it might be impossible to guess the value of those options in advance. So what's the option exercise price? And so that might be a situation where the best offer arbitration could be a tool if the JSC can't figure out what that option price ought to look like.
Okay, so those are the key ingredients in a successful IP framework for innovation, right? Clarity of purpose, joint governance, the joint steering committees, maximizing total innovation value, and finally these great points you raised about flexibility and optionality. How do we apply them, right? In what situations do these frameworks make the most sense?
Well, they're ideal when the technology is new, the stakes are high, and collaboration may be essential to innovation. They are typically used in long-term strategic partnerships where the parties need to navigate unknowns together to unlock the full value of innovation in an emerging technology.
And on the other hand, they're not right for every deal. If the scope is small and the value is modest, or the work is routine, the overhead of something like a JSC and the dynamic allocation of IP rights as you go just may not be worth it. So in those cases, the simpler model makes more sense.
And what are those trade-offs? What should parties be prepared for if they go down this path?
Julian, the big trade-off is effort. These frameworks require more communication, more structuring, and more trust. In the negotiation phase, you need to work on that clarity of common purpose and make sure it's embedded within the entire deal. Once you sign, you can't just put the contract in the drawer and move on. You have to actively participate in governance and decision making within the IP framework described in the contract.
Yeah. But if the innovation truly is emerging and the upside is significant, that investment that Brad's talking about can really pay off. You get stronger alignment, fewer disputes, and better outcomes for both parties.
Okay, well, wrapping up then, what are the key takeaways for contracting for emerging technologies using IP frameworks?
Thank you, Julian. Wrapping up, the key takeaways for listeners for contracting for emerging technologies using IP frameworks are: first, at the start, clearly define your common purpose and your guiding principles. Second, establish a joint governance structure with the authority, composition, and procedures necessary for making real-time decisions on IP issues. Third, in the contract, allocate developed IP to maximize value, to create the right incentives to, as Julian, you said, to seek out the largest possible pie instead of the largest share of the pie. Fourth, provide for reevaluation and adaptation. And as Spencer said, this can be in a wide variety of forms, and it's very well worth putting in the time in advance to identify how options like license options, buyout options, and so forth can allow you to dynamically shift and pivot and adapt as new opportunities come up within the framework of the innovation opportunity and the implementation of the emerging technology.
Great, thanks, Brad, and thank you, Spencer. I really appreciate you coming on the podcast to tell us about this important topic. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about anything related to technology and IP transactions in the law, please email us at techtransactions@mayerbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.